IVM.
Welcome to All Things Policy, a daily podcast by the Takshashila Institution. We are a bunch of policy nerds based in Bengaluru, and we like bringing fresh perspectives to Indian affairs and Indian perspectives to global affairs. So grab a cup of coffee, sit back, and join us for today's chat.
Hello and welcome to All Things Policy. I'm Prateek, and today I have Rohan with me, and we'll be talking about the concept of cross-border access to data for law enforcement purposes. Now, as we rely more and more on digital platforms to communicate, they're also becoming an increasingly important part of criminal investigations. This is reflected in some of the transparency data that a lot of these platforms put out. For example, between the period of Jan to June 2020, India made about 11,000 requests to Google for data in various forms. In the same period, it made in excess of 35,000 requests to Facebook. And India also accounts for the second highest volume of requests to Twitter, accounting for about 1/5 of them. And even TikTok, which is incidentally no longer available in the country as of second half of last year, we still made 103 legal requests to the platform. So before going any further, let's talk about this, right? Why do we need cross-border access to data? Why is this important?
Hey, before I actually answer that question, can I just say I love how into the weeds this podcast is going to go, and I think this is the pairing that no one asked for because there's no buffer between us, Prateek. So let's let's get right into it. So I think the case for cross-border data access is actually quite interesting because generally what happens is that a lot of our communication has moved online, right? And because of that, a lot of the evidence that let's say criminal investigations entails has also moved online. So what generally happens in the case of law enforcement, at least the argument is that regardless of where the data is stored, for a state to maintain security for its own citizens, they need access to cross-border data. Because generally we have seen that most social media platforms where this communication occurs tend to be based out of the US and more recently China. And so because some of our data can be stored there or maybe in a data center where it is more convenient for them, doesn't matter where it's located, but for the purpose of the investigation, this data is extremely important. And so that's why the case for law enforcement agencies to have access to this data is quite critical. And that's why you see provisions like data localization or these new these new intermediary rules asking for traceability and so on. Because there is a genuine law enforcement case to be made there. But yeah, I'll leave it here first and then we'll go into more.
Okay, I think that's interesting. So, yeah, as you said, one of the functions of the state is to provide security, and the argument being made is that it needs access to data to be able to pursue that goal. Now, in terms of how this happens today, we have different types of arrangements that can service this goal, right? Could you tell us a little bit about that?
Sure. So let me start with the frequency of how much it happens. I think I read a paper, and this is in my newsletter. It's a brilliant paper by Carnegie India, and it's got a couple of researchers. I think Prateek and Smriti Parsheera. I hope I'm not butchering the names, but the paper mentions that, and this is a Europe focused stat. So let's focus on that. Per the European Commission estimates, electronic evidence is needed in around 85% of criminal investigations, which is just quite nuts if you think about it. Like
Yeah.
85% of criminal investigations need electronic evidence, right? And of course, India doesn't release such transparency reports. But as you mentioned, the one good proxy that we have for looking at how much of this is India reliant on, the requests to Google and Facebook are quite common. And so the paper says that Facebook received 49,382 information requests from India in 2019, three times higher than the request volume in 2016.
Wow.
Which is just nuts. And given the fact that in 2019, we weren't actually as reliant on Facebook and WhatsApp as we are today because of the pandemic. I think a bigger portion of our communication has moved online, right? And so this is where we are. Like, this is this extremely important bottleneck that we are at. And the way this happens today, and this is where the paper gets interesting, there are three sort of broad instruments that law enforcement agencies use to access data domestically. And then there's one major sort of instrument that they use to access data stored abroad. Okay, so the instruments used to access data domestically Section 91 of the Criminal Procedure Code, the IT Act of 2000, and the Telegraph Act of 1885. All of these provisions lack adequate oversight and safeguards. Now, when I say they lack adequate oversight and safeguards, let me just give you an example, because unauthorized access is quite common. So, according to the paper, and this is data from 2013, so take it with a pinch of really stale salt. But we found that in 2013, in Himachal Pradesh, 1,371 phones were tapped, out of which about 170 were authorized. So you can imagine how big a gap there is between implementation and oversight and safeguards, right?
Yeah.
And the union government, and this is according to the paper, the union government alone issued between 7,500 to 9,000 telephone interception orders monthly. And this is not counting requests made to social media companies or internet service providers. So there is just this inherent need to get access to data through tapping telephones and through reaching out to social media companies. And all of this is
There's no need for judicial oversight as well, right? For a lot of these requests.
minimal need. I mean, if you just look at the example, I think we can link the paper in the show notes.
Yeah.
But just the minimal possible need. I mean, if you see that 170 instances are being authorized in Himachal Pradesh and 1,300 of those are being carried out.
Yeah.
So you can see that there may or may not be a need, but no one's checking whether or not those needs are being met for oversight and safeguards. Right. So it's quite a terrible situation that we're in. Now, moving on to what happens when we want access to cross-border data. This is generally done through a process called MLATs, which is the full form of which is Mutual Legal Assistance Treaties. And the idea here, and this is almost a pre-internet conception, which is that if a country wants access to data stored in another country, they have to go through this process called the MLATs. And the idea here is you have to meet the judicial sort of, benchmarks for two countries, right? For India and for the US. And it's quite a terrible position to be in because this process just can't handle the volume of requests that comes through typically in the social media age. Because I think this is a stat from a paper by the Observer Research Foundation. But one MLAT request takes an average of 10 months to process. Now, as you imagine, this is just not the time frame that law enforcement operates in.
Yeah.
You can't have the need to access evidence in one day and then have that need met 10 months later. That's just not how things work. And so that process is fundamentally broken and not fit to be a part of today's process, that where we should have been. It's just not adequate. And so that's sort of where we are right now.
Fair enough. I guess the next thing to look at is what are other countries doing at this point? Because I know this is obviously not a problem just for India alone, right? I expect the EU is going to be up to something as well. So what's happening on that front?
So there's a bunch of things that other countries, or in the case of EU, supranations are doing to sort of get this done, because MLATs are a problem for everyone. And I think, at least for me, the most interesting of those efforts is this thing called a direct access agreement.
Mm-hmm.
So the idea here, and I think the prime example of this comes from the US Cloud Act. The idea behind a direct access agreement is that two countries can enter into this executive agreement. So, for example, the US decides that, let's say, India is a good state to enter into an executive agreement with, or India can decide that it wants to enter into an executive agreement under the Cloud Act. And based on that agreement, the processes to get access to cross-border data can be met at a speed that's just not possible under the MLAT process. Now, the paper itself says that direct access agreements are not perfect, and I tend to agree. The other thing that the paper doesn't address is that they're actually a massive step up from the status quo. So I think that's something that's worth considering. But having said that, there's a bunch of things that the paper says that India should do, and I think I'll sort of talk about the three broad things here.
Yeah.
The first one is, and they say this quite unequivocally, we need amendments and new laws to have the requirements of lawful purpose, proportionality, and safeguards. So not only do we need to amend the IT Act or the Telegraph Act or Section 91 of the Criminal Procedure Code, we need to do so so that the standards of lawful purpose, proportionality are met, and also there's adequate safeguards to make sure that this sort of new amendments are not exploited. So that's number one, right? The second thing is that law enforcement agencies need to be efficient and also accountable when they are accessing this data. So, for example, they should collect the least possible amount of personal data necessary and destroy it once it has served its purpose. Now, in response to that, I'm not exactly sure how you would go about achieving that, because generally the umbrella of national security is used quite often and quite broadly. So it's a nice idea to have, but to the fact that whether or not it's going to be effective, I guess it depends on how well it's implemented and how we go about making sure it happens. So on this recommendation, I'd give it a 5 on 10 if we were rating this. And also, finally, India needs to form slash be a part of an international system that makes data access easier and fair. Right now, we seem to have sort of missed the bus, because if I don't know if people have paid attention, people who listen to this podcast, but long time ago now we had this thing called the Budapest Convention,
Yeah.
And India wasn't part of it. And the reason that was sort of laid out on why India wasn't part of the Budapest Convention is because it wasn't part of framing how that negotiation would go. And so, because we didn't have a seat in how in making sure what the Budapest Convention would require us to share, we sort of did not sign on for it, which I think is a fair response, because if we have such a huge populace and our system is so overburdened, plus we have such high volume of requests, I think we should be a part of how this thing goes forward. And the fact that we're not is sort of reason enough for us to say, listen, why don't we miss the bus on this one? But generally, I think if we weren't part of the Budapest Agreement, we need to be a part of something else that sort of takes its place or supplements it in some way. So yeah, that's where we are at.
Okay, I just want to go back to the point of the direct access agreement. Right now, I think I get the case that they can be more efficient. But one of the things that got my attention, in the same paper that I was also glancing through it, is this, what you're essentially doing with that process is you're taking away the involvement of government agencies in the second country or the country you're requesting for data, which means you're effectively making the platform or the company you're requesting this data from, they become the ultimate protectors of due process, or you can go as far as saying human rights, depending on who's requesting or who's doing this requesting, right? And I think that has some interesting implications given the scenario we find ourselves in now, right? With tussles between countries and big tech companies. Take for example in India and Twitter, the most recent case. Then, as you alluded to, the fact that we've just enacted rules that require companies to identify the first originator, right, of a message. And I think so. I think that part is interesting. It got me a little concerned, right? What do you think of that aspect of it? And if there a way around it?
Well, that's a broad question. I think specifically pertaining to the originator of identifying the originator of the message, I think so. The government's response will basically be, we just want the first originator where the message came from. We don't actually want the contents of the message. To which I would say, it's I can't think of a use case where you wouldn't already have the contents of a message and then go after the first originator, because you for example, you only go after where this message is coming from once you know what the message is. If you know it's harmful, you're going to go after the originator. So that's a bit concerning. But generally, I would say, as with regard to the direct access agreements, I think I would like to quote the paper here, which is that the paper basically says India will need to develop a strategic position on the adoption of direct access agreements. Instead of treating the Cloud Act or any other available model as a fait accompli, India should develop its own international agreement on direct access to data, which is sort of what I was saying with response to the Budapest Agreement, right? So the Budapest Convention. Doing so would ensure that any future negotiations on the subject will not be shaped solely by the positions set forth by potential counterparties. So you're thinking the US government, Facebook, or Google, so on and so forth. And given the complexity of issues that are at play here, spanning across domains of international relations, law enforcement, and civil liberties, the task of formulating India's position on the subject should not be left to the discussion of executive negotiations, which I think is fair, because executive negotiations only have two parties, the two governments, and maybe consider the US tech complex, but it won't actually have the interest of civil liberties at stake there. So yeah, have I answered your question in any meaningful way, or have I just been
Yeah,
talking?
I think yes. I was just curious, right? Because I think my approach to this would be to take off the law enforcement hat and put on my semi-activist hat, right? And that's where the question
I mean,
came
semi-activist
from.
hat makes sense.
Yeah, so and that's really where the question or the worry came from, right? And then I guess the way I see it is that there's going to be a continued need to create some sort of pressure on these companies to act to safeguard citizen rights, right? That's a very tricky situation to be in. It's not a situation we want to be in, but I think what I'm essentially saying is that it becomes hard to then just look at these companies as people who are just or entities who are just beholden to their corporate interests and their shareholders. I think there is a larger purpose, and that argument has been playing out right in the public sphere in various forms over the last years. But I think things like this sort of draw that a little bit more into focus, at least for me.
I think there are two sides to this actually. I mean, there is the side that you mentioned, and then there's also the
Yeah.
side of how these companies sort of deal with law enforcement. So, for example, like entities like Google, Facebook, or Twitter maintain separate systems through which law enforcement agencies can submit and track requests. So, and TikTok has a different system which may or may not be active in India in the near future. But the problem is that if you tell a law enforcement agency that Google wants these documents, Facebook wants these documents, and Twitter wants these documents, it's sort of like it's not the most efficient way to go about this, in the sense that what if Google wants the particular email address of the person that you want, Facebook wants a Facebook ID, and I don't know, PAN card, Aadhaar, or whatnot, and there's a bunch of different requirements that each of these companies have. The efficiency on making these requests takes a hit. And so one of the ideas, at least in the paper, is that you have sort of a standard template that law enforcement agencies should follow. So that all these companies, their benchmarks are met in a way that law enforcement doesn't have to overly be like, oh, what does Facebook want now? What does Google want now? All of this is sort of standardized in a way and moves forward in a more efficient manner, I guess. So yeah, there's two sides to this. The one that you mentioned, and also how these companies are interacting with law enforcement right now. And at the risk of irritating the listener, there are no easy answers here. And that's honestly just, it's something that we have to sort of fix going forward. But I don't think this is being looked at in a manner which is going to be urgent and resolved in the near future. At least I haven't seen developments, not in India at least. I mean, that the EU has been talking about a direct data access agreement. But in India, I think, at least I haven't heard of any news that's promising and meets this with the urgency that it should.
Yeah, and I think the sense I also get is that the first step in this direction needs to be some sort of reform in our in the surveillance framework, right? The legal framework governing surveillance. There has to be some form of reform there, and what we have on the table right now in terms of the draft of the personal data protection bill, at least the last we saw publicly, right, which enacted a lot of exemptions for processing data for law enforcement purposes, etc. It seems like we are some step away from there, a few
I
steps
mean,
away from there.
not just that, let alone the fact that we don't have a data protection law in place. Law enforcement agencies are actually using laws that have been struck down by the Supreme Court.
Yeah.
So not only do we not have a data protection law, but it's just that we are using laws that we essentially don't have anymore. So it's pointed out
in fact, I think the IFF also has a tracker for it, right?
Yeah, they do, and like those folks are really passionate about how. So this section is called Section 66A of the IT Act, which was invalidated by the Supreme Court's decision in the Shreya Singhal versus Union of India case.
Yeah.
And you would be surprised how often Section 66A is still used despite being struck down. So I think essentially this is the worst of both worlds: not having a current law, and also usage of a law that was essentially deemed as draconian and then struck down. So I honestly am at a loss for words as to a situation here. But as you said, things might get better once we have data protection law, and that sort of instills a more standard here and just makes this process a little less vague and more straightforward. But that's coming from a person who is generally more optimistic about things than you are. So yeah.
It's a good point. And I guess if citizens' rights aren't enough of incentive to regulate on this front, there were developments last year with the Schrems 2 case as well, right? Which provides maybe an economic angle to this, where the privacy shield that was being used between the EU and the US for a flow of data was deemed insufficient, right, or inadequate.
Yeah. I think my main takeaway from Strems 2, and I think the most important point that I at least have come across, is that generally I have seen the US and EU as one block for a large period of time before the GDPR came out, at least in their response to how data should be treated. And I think that's a failure on my part. But Schrems too has basically said that, listen, the EU doesn't think that the US is going to provide adequate safeguards to their data being stored there. And I think part of that's because the US doesn't have a data protection law. And I think you could also apply that same statement to India. Because even if we did have a data protection law, I don't think that scenario would change because it does have sweeping provisions for the government to be able to access data, which is something I imagine the EU will also not be comfortable with. So not only has the EU not deemed US as adequate as of now, I don't think they're going to, if the current version of the data protection law goes forward, I don't think they're also going to deem India as adequate. So it's interesting. We're living in these times where things don't look as optimistic, even with a data protection law, especially pertaining to cross border data access. But I guess we'll just have to wait and watch.
Yeah, but I think it's also important to point out that when we're talking about Schrems 2 and adequacy, it's more from the perspective of the data of an EU citizen in other jurisdictions. And when we're talking about cross-border access for law enforcement, then we're talking about data of an Indian citizen in another jurisdiction, right? I just thought it's important to make that distinction.
Yes. I mean, not always Indian data over, but yeah, mostly yes.
Yeah, fair enough.
So yeah, I guess big message of this is that cross-border data access is sort of harder to achieve than most people thought it would be, and that's why we have these sort of indirect measures to get there, like localization and other rules regarding encryption and traceability and so on. And unless we come up with a better way to deal with this, I think we're going to have such provisions that not only sort of give the government this power, but also break a bunch of other things in the process, which is not a good place to be in. But one thing I would like to add before I finish is that a lot of think tanks. I mean, I've worked in the Indian tech policy industry for a long time, and during my time there, I have seen think tanks work for months. I mean, just getting the fonts right and so on to just produce a PDF that absolutely no one is going to read, and that's sort of interesting to me because I like reading these PDFs when I have some off time, but I don't think anyone else sort of reads them as much. And so I have started a newsletter that we will plug in the show notes, hopefully, Prateek, that talks about.
Yeah, absolutely.
Yeah, that sort of gets the main takeaways from these PDFs that no one's reading and is bite sized. So yeah, that's me.
Okay, yeah, and so just to sum up, right? It seems like we should be paying more attention to this concept of data access for law enforcement access. If not only to just facilitate these investigations, but also to protect individual rights. On that note, we'll conclude. Thank you for joining us.
Thank you.
If you liked our show, don't forget to check out other interesting podcasts on the IVM network. You can tune into them on the IVM Podcast app, ivmpodcast.com, or wherever you listen to your podcasts. You can also follow IVM on social media. The handle is @IVM Podcasts on Twitter, Facebook, and Instagram. And hey, if you'd like to dive into Takshashila's research on technology, strategy, and economic affairs, check us out at our Twitter handle @TakshashilaINST or our website takshashila.org.in.
I hope you enjoyed that show. If you aren't following us on social media, please do. We're IVM Podcast on Twitter, Facebook, and Instagram. Would like to thank the sponsors on the network this week. Siad, we really do appreciate your support. We have a new show on the network. It's called The Fighting Goat. And if you love fighting sports, tune in every Wednesday with hosts Arjun and Somesh. They also featured, by the way, on Cyrus Says this week, where the three fitness freaks bonded over their love for TV sports and sports in general. Tune in to This Round Is On Me, where Gauri celebrated her 25th anniversary with Kavita Rajwade, who is my co-founder at the IVM Podcast Network. They give us details about how this show was curated, and they talk about podcasts in general. On The Habit Coach, Ashton highlighted our addiction to screens, how we are glued to either a big laptop screen or a small mobile screen all day. He shared some tips on how to rectify this unhealthy lifestyle. On All Things Policy, Anirudh Kanisetti spoke to Prateek Waghre and Rohan about the new internet guidelines that were issued by the Government of India recently and their impact on content creators and platforms. On the Filter Coffee podcast, Karthik invited Vivek Ram, who is a celebrated animation artist. They chatted about his stint with animation and starting his own studio called Vanar Sena, bringing to life stories from ancient India and his scriptures with animation as his vehicle. We had Dhanya Rajendran, the editor of the News Minute, on the note with Maruk Inayat. It was a deep dive into the digital newsroom and the upkeep of truth in a fake news pandemic. And with that, we hope to see you again next week.
Hi, I'm Zarina Poonawalla, host of the Empowering Series podcast on the IVM network. I happen to be a peak performance coach and leadership coach by profession, and I'm here to share with you productivity tools, life-altering techniques, and real-life hacks to help you achieve your maximum potential in everything you do, your relationships, professions, careers. So tune in every Monday to unleash your inner power. Be safe, be well, be empowered.